Thank you so much. Criminal defense attorney Brian Shealy is joining us now to get some reaction on the proceedings today with the state Supreme Court. Thank you for your time.
My pleasure, JR.
What stood out to you today?
Well, it's interesting to have these justices who are legal, brilliant minds who we normally read speaking out loud the things that we are asking ourselves throughout this whole trial. I think it was Justice Hill today that said, we have Becky Hill a rogue clerk of court. And that kind of echoed out and started the thought process for me, because the justices are clearly thinking what seems obvious, but you're not certain they're going to say it in that exact same way. So that was striking to me right out the gate.
Yeah, you mentioned that. That was the Chief Justice of the Supreme Court who called her rogue, and he got the prosecution, Creighton Waters, to agree with him on that.
That's very true, JR. I'm not sure how Creighton could minimize or try to characterize it any other way, especially when you have a Supreme Court justice saying this is exactly what she was. So we had to agree with that. Then it became an exercise in diminishing what element of influence she had before the jury. And obviously that was debated between both sides, and the justices had their own comments on it.
Did you also find it interesting how attorney Dick Harpootlian talked about the different jurors? One that stood out to me, Juror Z, who he said under oath, Ms. Hill told her not to be fooled by the evidence presented by Murdaugh's lawyers.
Yeah, I mean, that is a strong point for the defense. I mean, really the legal constitutional standard for jury misconduct is anything that could show an attempt to influence. And so those words are strong. They're not, here's where you pay your parking, or here's where you get your check for jury service. I mean, it is a really intense kind of conversation piece to really push the jurors in a certain direction. And obviously, as Harpootlian said earlier today, the whole theory about why she did that was for financial gain with her book. And so you hate to see this, and you always want a clean trial, right? And I think the justices said in the very beginning, we have the best of the best here. We have the best prosecutors. We have the creme de la creme, criminal defense lawyers. Everybody is trying to do the best they can and uphold the integrity of the system and make sure that the defendant gets a fair trial and the state does their job. And then we have this outlier, Becky Hill, which could be a once-in-a-lifetime. I hope it's a once-in-a-lifetime factual scenario that pops up in a jury in South Carolina.
That is the Becky Hill issue of this case. But on the other issue, the financial crime evidence being submitted during the original trial, it seemed to me that justices were really coming down today on Judge Clifton Newman for allowing that to happen.
I agree, JR. They did. I mean, normally in a big case on an appeal, if this amount of bad character evidence, where the state is attempting, or a judge allows really, not for the defendant to be tried on the allegation at hand, but on other matters that are unrelated to the allegation you're on trial for, that's bad character evidence. And we hear a lot about lawyers calling it 404B. That's the evidentiary rule. And it's, as I believe Justice Kittredge said today, it's a rule of exclusion, right? So it's meant to keep it out. It's not like, hey, this comes in and then let's just see where it lands. It is always meant to be kept out unless you can really show a motive or a common scheme or plan. That's what the rule talks about. And so here we have Creighton Waters tried to say, well, it's part of the motive because, he did this to distract the world from the financial crimes, which I think the justices kind of had a problem with, and they told him that. Mm-hmm. That was not very likely.
Talk to me about next steps, though, because it's going to take potentially months, and they have thousands. I was hearing this morning like 8,000 pages. A lot to read over and review.
Well, that's why they sit on the highest court in the state. They have the legal acumen to handle it. They also have a lot of staff that help them churn through the documents, and there will be rigorous debate. And they're going to look at the record. They're going to look at the arguments made before them. But yeah, this is not anything that could be decided in a day or a week or even a month. So we'll be waiting patiently for that, and then when it comes down, I'm sure we'll be quite intrigued on that result.
All right, we're going to pause the discussion at the moment with that, but you'll be with us throughout the hour. We'll be talking more reaction later in the broadcast.
All right, stay with us. Much more to come.